Welcome, everyone. It's my great pleasure to get to have a conversation today with a very distinguished alumnus of Duke Law School, Mr. Michael Dreeben. Michael Dreeben is currently a distinguished lecturer from government at the Georgetown University Law Center. But prior to that, from 1988 through 2019, he served in the Office of the Solicitor General in the United States Department of Justice. First as an assistant to the Solicitor General, and then as a Deputy Solicitor General. As Deputy Solicitor General from 1994 to 2019, he supervised the criminal docket for the United States in the US Supreme Court. So this is amazingly impressive. He has argued 105 Supreme Court cases on behalf of the United States and briefed hundreds of other cases in the Supreme Court and in the lower federal courts. He's also argued cases in every regional federal court of appeals, including en banc cases in 10 of the circuits. So I can't tell you how delighted I am that we get to have a whole hour of conversation with Michael to find out all about his career and what we can learn from him. So first, let's welcome him.
Thank you. It's great to be back.
So let's start with the basics. Tell us more about what the Solicitor General's office does and what you did there.
So the Solicitor General's office has a monopoly on Supreme Court litigation for the United States with very few exceptions, which means any government agency, any United States attorney, any independent agency that wants to have a case presented to the Supreme Court or is defending against a private party's petition needs to come to the Solicitor General's office. We are a tiny office by the measure of the amount of work that needs to be done. There's 21 lawyers, 16 of them are career. There are 4 deputies, 3 of the deputies are career. There's 1 Solicitor General who's appointed by the President and needs to be confirmed by the Senate, and by statute is required to be learned in the law, one of only 2 officials in the Department of Justice who has to meet that requirement, although the rest of us try also to be a little bit learned in the law. Unfortunately, had a great launching pad of an education at Duke to get us to that point. The office's work takes place within the Department of Justice. And I have to admit that before I interviewed there, I didn't fully understand that. The office has a little bit of a reputation that goes under the name of 10th Justice. Sometimes the Solicitor General is referred to in that way, which is meant to convey not really that the Solicitor General has a voice in the Supreme Court's deliberations. It would be nice, but it doesn't actually work that way. They make their own decisions. But it does refer to a special obligation of the United States before the nation's highest court to exercise a high degree of respect for the rule of law as administered by the Supreme Court. Not only loyalty to the executive branch's interests, but also fidelity to the underlying principles of law that the Supreme Court is seeking to apply. And having gotten that conception of the office, I envisioned it in some building off by itself in Washington where people went in and thought great thoughts and then said whatever they wanted to say to the Supreme Court. And this was probably a little reinforced since my first introduction to the Solicitor General's office was studying under Professor Sarah Sun-Beal, who certainly seemed to me to be the kind of person who could dream up really great thoughts independently and then present them to the Supreme Court. Then I got my invitation to go interview, and I discovered it's on the 5th floor of the Justice Department, right down the hall from the Attorney General, and that's who the Solicitor General reports to.
So for a lot of us, I think this sounds like a dream job. How do you get there? Take us through your pathway.
So it really takes a lot of luck and a somewhat maniacal dedication to doing appellate law in most cases. I had a lot of the luck, but I actually was not an appellate lawyer before I went into the Solicitor General's office. I knew about the office from Professor Beal. I didn't really pay very much attention to it. I did a federal appellate clerkship, and then I wanted to be a trial litigator. So I went into private practice in Washington, D.C. I did a couple of appellate cases, but most of what I did was kind of grinded out litigation. Then I did some international arbitration, and then I did securities enforcement work, all of which is terrible preparation for going to the Solicitor General's office. But I had a friend who was in the office who I had worked with in private practice, and he told me that an opening had come up, and for reasons that I still don't entirely understand, he suggested that I apply, and I did. And a couple of months later, I got an interview, and I went in, and all the people that I met there were recent Supreme Court clerks. They had just come off their 3-year bar where they were prohibited from appearing in front of the Supreme Court. And they were very conversant with all the recent jurisprudential decisions, and they could talk offhandedly about the cases that they had argued. And I could talk about the pro bono case that I had argued in the DC Court of Appeals, where I had desperately avoided filing an Anders brief only by finding an legal error that had been totally forfeited by anyone, and the court affirmed that conviction 5 days after the argument. So went through the interview, I left and thought, it's probably not a job that I'm gonna get. And it seemed like they thought so too, because 8 months went by before I got a call. And I finally got a call. The Solicitor General was hiring 4 people, and he was hiring 2 people right off of appellate clerkships to demonstrate that he was capable of bringing new people into the office who weren't political in any way. And he wanted to hire 2 seasoned litigators. And for some reason, he thought I was one of those. So got the job and started in.
So you mentioned Professor Beal as being a kind of mentor for you in law school. What else about your Duke Law experience do you think helped?
Well, I think that in part, what you get from a kind of education like this is curiosity about everything and encouragement to follow your interests wherever they lead. And I think this is one of the most important things that comes out of a general legal education that's not designed to track you into one thing, but allow you to discover what really is your passion and your interest. Because there's a lot of pathways in law that lead to very unhappy people. And I think that the 2 main causes of that are kind of mismatches between who you are and what you're doing. And the second is, unfortunately, financial. And the reality is if you have student loans and you need to pay your student loans, then you need to take routes that are appropriate to that. But it is very easy to get distracted in this profession by monetary expectations and the kind of things that your peer groups are doing. Whereas in fact, you may discover what I really love about law is helping people. I want to have them in my office, I want to meet with them, I want to see their problems, I want to resolve it. And the last thing I ever want to do in life is write an appellate brief. Or alternatively, you may discover that people are fine, like if they're in your family, but clients are not, want so much of them. And I'm not saying that appellate lawyers don't have clients, because they do, but you spend a lot of time with books, or we used to spend time with books. I think now people just spend time with computers. But I kind of encourage you to take those books off the shelf. So one other SG story that connects to Professor Beal. I was out in private practice, and it was before I had applied to the Solicitor General's office, and I was doing some legal research with a US Reports, and I opened it up. And one of the things you get when you work with books is random things in the universe that find you. So I was not looking for a case that she had argued, but I flipped open the book, and there it was, right there. And I looked down, and it said, Counsel for the United States, Sarah Sun Beal. And I thought, wow, that is totally awesome. I had only seen one Supreme Court argument in my life up to that point, and it was when I was 12. My parents brought me down to Washington, and we were on the 3-minute line, and we went in, and you sit way in the back, and you see these people sitting up on the dais, the bench, high above, and some poor advocate down there having to talk in front of all of those people. And I thought, that is the most terrifying thing I've ever seen in my life. I never want to do that. But then I flipped open this book and I saw, like, well, she actually did it. And here it is. It's in history. It's in these books. And it was very kind of an awe-inspiring moment. And then later I got the call to apply, followed it up.
I had a similar reaction going to the Supreme Court. So I've only been twice. And in both times, I was the author of an amicus brief, and I was going to hear the argument that the real lawyers were making. And, you know, I have to speak for a living. I'm a dean, and I was a professor before, and I'm not that nervous about public speaking. And even being like 3 rows back from the people who were actually making the argument terrified me. Like, I started shaking. And I think part of it is the history thing. You know, it's like, you know that this is a historic event and you're in the middle of it in a way that just motion practice in front of a federal district judge did not feel that way to me. So did you feel like that? And did it ever go away?
So absolutely, the first time that I did it was completely terrifying. And the fear factor was amplified by the case that I was given to argue and the circumstances surrounding it. It was a double jeopardy case that had come up out of the district court in the Southern District of New York, and it was one of the last cases that could skip a court of appeals and go straight to the Supreme Court in a direct appeal. Very rare now, but it was a little bit more common then when a federal statute had been declared unconstitutional. And the case involved a guy who had committed Medicare fraud, and he had done it by overbilling Medicare by about $3 on a large number of claims. And if you do enough of them, you can actually make some money. But didn't work out for him because he was prosecuted, convicted, and sentenced to prison. When he got out, the government sued him under the False Claims Act. And the False Claims Act at the time provided a fixed $2,000 monetary penalty for every false claim. So his false claims were $3 or so. He had a lot of them, I think 585 or so. Not a math guy, so I'm not going to run the numbers, but it added up to over $100,000 of penalty. And in the district court, the judge said, well, that's criminal punishment. Double jeopardy clause bars it. Case goes straight up to the Supreme Court, and I arrived in the office after the case had been briefed. The deputy on the case kind of looked at the facts and said, not for me. The assistant on the case said, let's give it to the new guy. So I inherited this case, and I was really all enthusiastic about it until I started reading it and thinking about the hypothetical questions that the court was going to ask me. And I was really nervous, and I walked around the neighborhood with my wife for about a month, sort of agonizing about this, and she told me it was going to be okay. My fear that a pit would open up under me and I would just drop away if I flubbed an answer, she said it was probably not true. Then I did a moot court at the Solicitor General's office, and your colleagues read the briefs, seek to impersonate the justices, not justice for justice, but in their style and in the questions that they might ask, and they reduced me to tears. And it's kind of hard when you're like supposed to do an hour moot court, and halfway through it, you feel like just kind of running out the door. So by the time the argument actually came along, I had a pretty high level of terror. Now, the defendant in that case actually did not appear in the Supreme Court. He couldn't care less. He wasn't going to pay any money. He was basically bankrupt. So the court did what it sometimes does. It appoints a lawyer from private practice who's a recent clerk for the relevant justice whose circuit the case came from, who is trying to get a start in the business. And in this instance, the Chief Justice appointed another young lawyer making his first argument. That lawyer was John Roberts, current Chief Justice of the United States. So we're both in court sitting there waiting for our first arguments, and we're kind of like hanging around watching this gigantic clock. You really should go to the Supreme Court if you get a chance to. It's a magnificent courtroom. It really expresses the power of the law. and those like gigantic marble columns, which when you're sitting there in terror, you're hoping they don't fall on you, and the velvet curtains are all very intimidating, but it's the clock at the top of the courtroom that has like the most intimidating effect, because it's kind of clicking towards 10 o'clock. And at that point, it would be super embarrassing to get up and run out of the courtroom. So I'm there, clock's getting close to the end of the, witching hour, and John Roberts, who is white as a sheet, sitting on the other side of the podium, leans over to me and says in a hoarse whisper, "Do you want to settle?" So, no time for that. Whistle blows, justices come in, I have to stand up and begin the argument, and I begin it, and it's got all of these frauds, remember, that are $3 a piece, and you have to pay $2,000 a pop for each fraud. And I get out my first sentence, whatever it is, and Justice Scalia then interrupts, says, "Counsel, let's just stop right here." It's like, you're saying that for every single fraud that this guy committed, every time he defrauded the government $3, he has to pay $2,000 for each fraud, no matter how many he does. Yes, Your Honor, that's right. Doesn't Congress understand the concept of volume discounts? The whole courtroom breaks into laughter, and it went downhill from there. So when I kind of joined the Solicitor General's office, one of the things that seemed kind of majestical about it, and I guess it sort of is in abstract, is that you can have the United States, the most powerful government that's ever been on the face of the earth. But you've got this court that can get an argument from the United States government, listen to it, and reject it and say, "No, the law does not support it, you're wrong." And I completely and totally believed in that until I lost my first case unanimously.
So that makes me think of another question I was wanting to ask you, which is kind of about, what do you do when you're in a job and you get cases that you just don't agree with the position that your client's taking? And so that must have happened to you sometimes, both in private practice and in your position at the SG. And so I'm interested in knowing kind of, what do you do when you have a case like that? But then also, as all of us are thinking about our careers and what we want to do and don't want to do, how should we think about that long term? Is it okay to occasionally have a case that you don't agree with, or is it really important to be kind of aligned over time with the kinds of clients your law firm represents or the entity that you represent?
I think that is a really important question for people, especially who are entering the profession. And it's probably a question that continues through law school and throughout your entire career. I can recall very distinctly that when I came to law school, I had sets of values, some articulated, some not, and I was learning to be a lawyer, and I thought that what I did as a lawyer would have to and should align with what I believed as a person. I'm not saying that lawyers aren't persons, they are. Corporations are, certainly lawyers are. But I had this disconnect when I discovered really that being a lawyer, for most aspects of being a lawyer, is representation of another person. And your job as a lawyer is not, in most instances, to further what you believe personally, but to take on the role of representative, make the arguments for your client, serve your client's interest in a negotiation, be able to not allow your personal views to detract from your representation. Okay, so that's a little bit of an idealized type of the idea of representation, but Dean Abrams' question really goes to the heart of a personal decision that everybody has to make, which may vary at times and vary over your career, but it's how closely do you believe that what you do as a lawyer has to align with what you believe as a person. And that is a different calculus for every individual, and it can vary depending on what you're doing. If you discover, and there's nothing wrong with this, but if you discover that you're a person where you have to be very closely committed to what you're doing as a lawyer to further whatever your objectives are, then probably you're going to be happiest if you find a professional home that basically aligns with those views, whether it's public interest or government or some other activity. Ideology should probably play a role in the selection of what you're doing, and then you'll be around people who are similarly motivated, and you'll feel a greater sense of satisfaction. At the other end of the spectrum, there are very good lawyers who think excellence in doing what they do is the most fulfilling thing, and they can vote however they want to vote or have any opinions they want to have, but being a lawyer and having opinions are two different things. And they will be quite happy in other lines of work where you don't have to agree with your client. You may even hate what your client is doing. It could range from you're at a corporate law firm and you actually think the corporation is evil, but they're entitled to a defense. Or it could be representing somebody who's accused of murder. Or it could be, as the ACLU did when the Nazis wanted to march in Skokie. The ACLU was not aligned with Nazis, but they were in support of the First Amendment. You could argue that that fits into both buckets. But that's a different model. Most of us are in between. And when you're in between, it is somewhat of a sliding scale, and some cases will trigger your desire to not be a part of it, and others you will say, I'm a professional, I'm going to do my job, and it's okay. And figuring out where that balance is, I think, is a very important factor in having professional satisfaction and being able to do the all-important thing of go home and tell your kids or your spouse what you did and look yourself in the mirror and feel good about it.
What do you think is special about the Solicitor General's office in terms of its role in developing the law? How did that feel different to you from private practice?
So one of the unique features about the Solicitor General's office is, although it is not independent, it doesn't have a 10th justice role, it is part of the executive branch, reports up through the Attorney General to the President, serves Article II interests. It also functions as a translator and a communicator of what the Supreme Court is saying. So as an advocate before the court, I learned about the cases from people who knew a whole lot more about them than I did. But it was then my job to translate them and speak to the court in language that the court was comfortable with. The court's commitments were not aligned with the viewpoints of the agencies that I had to represent. They wanted to get the law right. So in order to advance the interests of the clients, I had to be able to synthesize it and put it in the framework of law that the court would go with. And sometimes the court's law would push back. And you had to be able to go back to the client and say, this isn't going to work. We're actually going to have to change our position. And you know what? Even though they are the Article III branch, we're Article II branch, we have our own responsibilities, we are part of one United States government. And my ultimate client here is the United States, not a particular agency or a particular prosecutor. So we, unusually among litigants before the Supreme Court, could do something that's known as confessing error. And all of that means is discovering that based on a neutral application of the law as best you can analyze it, the government won below, but the government was wrong. And in the government, as distinct from a private, you go to a private client, you say you represent Corporation X, and they defeated this judgment. Somebody was seeking $1 billion from them, and they managed to get it thrown out on statute of limitations grounds. And you discover, you know what? The law doesn't actually support us. You go to the client and you say, I think we should confess error. You're probably not going to be their lawyer any longer. But in the government, if I or colleagues felt strongly that we took a wrong turn, it should be fixed, there was a deliberative process where you could express that view within the department, usually through memoranda and discussion, and doing it respectfully, not sort of, you guys who did this down below, it's like something wrong with you. No, you're part of a team. Almost everything that you do in law, really, when you get out, except possibly being a professor, and I'm not even sure that that applies there, it depends on teamwork and learning to work with people, especially people who you may not agree with or who may not be your natural best buddies is indispensable, I think, to having a happy and civil career. So in the process of figuring out, are we going to confess error? You put your views on paper, other people get to respond to them, and then there's a process for deciding it. And then if we concluded that the right thing to do was to confess error, we would tell the court. Sometimes the court would agree, but the court was not bound. Sometimes it would not.
Do you have any particular cases we could hear about where that happened?
Yes, I had a series of cases that kind of like grew out of a series of disasters that I had when I got the job of being Deputy Solicitor General. It's like a fantastic job. I was all of a sudden in charge of the United States position in criminal cases nationwide. And the first thing that I did with that was lose the first 3 cases that I argued, creating massive headaches for all of my client prosecutors. One of them involved a federal statute that prohibited using or carrying a firearm during and in relation to a drug trafficking offense or a crime of violence, 18 U.S.C. 924C. And the government had succeeded in persuading every lower court that a drug dealer used a firearm if he had it locked up in his room that emboldened him to engage in drug trafficking. Because he knew that, if I got in trouble, by the way, it's not a safe profession. You guys have made a good choice. Drug trafficking kind of requires that. That's why they say guns are tools of the trade. And the prosecutors took that maybe a little bit too literally. And so we had lots and lots of people locked up on mandatory 5-year sentences for having a gun passively at their home instead of using it. And the Supreme Court got that case and unanimously said, no, use means use. End of case. But the result was that there were thousands of people who were in jail who were convicted based on facts that didn't ultimately constitute the crime. And a lot of those people had never raised that issue. So you had the collision of the doctrine of procedural default, which means if you don't raise a claim in a timely manner, you can lose it altogether. And even if there's error in your case, it's too bad. The legal system doesn't go back and correct it. And the principle on the other side, which is, well, if there's a manifest miscarriage of justice, something has gone really awry, we cut through that procedural default and we allow you relief. It's a little bit like the balance of law and equity. It's an equitable exception to a seemingly rigid and harsh legal rule. And we had won a case where the court said, nope, the procedural default doctrine applies because legal error is not the same thing as a miscarriage of justice. That means factual innocence. And I thought that doesn't seem right because the two doctrines result in the same thing. Somebody who's in jail when Congress has not found that the conduct that they engaged in is actually a crime. So we went through a long process of how to reconcile those two doctrines, ultimately filed a brief that said the defendant should win if he can show that the conduct he engaged in wasn't a crime. And I went up to the court and argued that case. And because we were on the side of the defendant halfway, the defendant argued, I argued, and then somebody argued to defend the position that the United States had abandoned. And when I got up, I was saying a lot of the same things that the defendant was saying. And one of the justices looked down at me and was puzzled, said, wait a minute, I expect this from a defendant, but you're the government. And I said, yes, but the government has an interest in imprisoning the guilty and freeing the innocent. And ultimately, the court agreed 7-2 with our position and upheld the confession of error.
Wow, that's really astonishing. Maybe we could turn to where you think the court's going now. What are the most interesting legal issues that you think are going to be before it or are before it right now?
So I think that two of the cases that are extremely interesting that are before the court now are a firearms case that grows out of New York and a separation of powers case that the court has not yet added to its docket. They're sort of at the opposite ends of the legal constitutional spectrum. One is about individual rights. One is about the fundamental structure of government. And the New York case really poses a critical question that the Supreme Court has not addressed since it decided Heller versus District of Columbia, which held that there is a right of self-defense in the home that entitles somebody under the Second Amendment to possess a firearm. But the court did not address whether there's a right to carry or possess a firearm outside the home. The New York case may raise that question. I say may raise because it arose under a statute that New York has now repealed and replaced. And the question whether the court will decide the issue is before the court, and we do not know the answer to that. But that will require the court to really delve back into history and underlying principles and try to elaborate what is the Second Amendment right, where does it apply, when can it be overcome, and it requires really a fundamental balance between political perceptions of the need to regulate firearms versus the enshrined doctrine of the right to firearms in the Second Amendment as it was interpreted in Heller. And it comes to the court at a particularly fraught moment because of all the shootings over the summer and new legislative efforts to do something about that. The other case that I'm watching is called Law versus Consumer Finance Protection Bureau. And that is a separation of powers challenge to the provision that the director of the Consumer Finance Protection Bureau cannot be fired except for good cause. And it implicates basic questions about how much control does the president have to have over executive officers in order to be able to fulfill his or her Article 2 responsibility to have the executive power vested in that individual and to ensure the faithful execution of the laws. And if you've studied separation of powers in constitutional law, or if you're going to get to it, you'll see that this has been a long-running debate, really has been, it was at the heart of the Andrew Johnson impeachment investigation and has later been elaborated by a succession of Supreme Court cases. It's at the heart of the so-called regulatory state and the existence of independent agencies. And so a lot is on the line with the court's consideration of that issue.
So you talked before a little bit about how the Solicitor General's office is involved in counseling the government about thinking not just about what the law is, but how it should develop. And you're still very focused on cases that have not yet come before the court. Can you say a little bit more about that? So over a 30-year career, there you are in this building that's, on the floor that's, right near the Attorney General. So there are political fluctuations that are going on in what the government would like the law to be, right? And yet you've got a set of principles that I assume matter to you that are constant through that whole process. And then you're thinking ahead to the cases that might come and thinking about how that would further shape the law. So kind of what's the effect of politics, I guess, on your role, when you're arguing cases before the court, for the government?
I'd like to say zero, but it's the fundamental determinants that I felt on me were having to go up and present a case to the Supreme Court and knowing that if what you were trying to sell wasn't properly grounded, they would yell at you. And that is not fun. And that really, it seems like maybe a small piece of how policy should be developed, but it makes very concrete that you're in a legal process. There are things that are going to sell in a different environment that are not going to work at all in that environment. It has to be channeled through law. So I really feel like the Solicitor General's office and other offices that are in the leadership structure, the Office of Legal Counsel, regard themselves as, I was going to say like conscience of the department, but that's maybe a little bit pretentious, and it's not actually the way that it feels to be there. You simply feel that, hey, we're in a department that's called the Department of Justice. It's not like most of the cabinet agencies. It's not named for a thing or an activity. It's named for an ideal and a principle. And every time you walk in that building, if you pay attention to what you see and the nature of it, and you think of the history of it, it reinforces that you're in an institution, the purpose of which is to uphold the law. And it's incredibly important that there be a separation between law and politics. So I think it's baked into the institution, and then it's baked into processes. It's a very process-driven enterprise. And unlike other activities and other companies or private sector stuff that kind of reinvent the way that they do business, the way we did business in the Solicitor General's office was probably essentially the same way as when Professor Beale was there, and probably 30 years before that, too. I can think of only a couple of dramatic changes to that. And it's basically a process where what you say has to be justifiable on paper in a memoranda. And if you wrote a memo, for example, if I wrote a memo to the Solicitor General's office that said, we should really advocate X because although the following 17 Supreme Court cases don't support it, it would really be good policy, that would probably be the end of my job. And it would certainly be something that would earn you scorn from people and confusion. Like, what are you doing? Like, that's not the way we do business here. So process and the traditions of the office exert a very powerful effect to drive people towards legal analysis. And I would say that during my time in the department, I saw a lot of mistakes. I made a lot of mistakes. Most of the mistakes that I saw made were a result of breakdowns in process. Substantive errors were almost always the fruit of procedural errors. And those procedural errors almost always were excluding people who should have been in the room when the conversation happened. And yes, those things did occur, and sometimes they occurred for political reasons, but they were departures from the norm, and they illustrate why the norm had virtues. My own mistakes, I'm not going to blame on procedure. I just made a lot of mistakes.
So you've established that it's a serious place. Mm-hmm. We've talked about how it's a terrifying place. Mm-hmm. But you also mentioned Justice Scalia getting a good laugh at your expense. Can you talk about humor in the Supreme Court?
I think humor it's a very important part of Supreme Court arguments. Usually it's the justices telling jokes, and remarkably, everybody laughs. It's usually a bad idea to try to do that as an advocate. There was one advocate who was arguing a case, and it involved green plums, and he tried to connect that to a bad digestive effect that green plums could have, and he connected it to Justice Scalia's wife. Not a good move. So you really don't want to do that. In fact, I think after he lost the case, somebody actually sued him for malpractice based on the argument. That is not where you want your Supreme Court arguments to land. Basically, you play it straight. So for most of the arguments that I did, I never actually went for laughter, but I did in one case. I had a case about the use of polygraph evidence in the military. And the military had a rule that in military court-martials, you couldn't introduce polygraph evidence for any purpose, either side, to prove the truth of having passed or failed. So we had a case where an airman had been blood tested, and they had found meth in his system. They had indicted him for possession of methamphetamine. And his defense was, it's true it was in my system, but it was a case of innocent ingestion. I went home, there was a pizza on the table in my living room, my roommates were there, I picked it up and I ate the pizza, and that's what must have happened. It's kind of like, I was thinking, takeout service, I'd like a pizza, please. Mushrooms, onions, and meth. I don't know that pizza service, but who knows? So he then, to bolster that defense, took a polygraph test in which he was asked, did you take meth? No. Did you eat pizza? Yes. Passed with flying colors. And just to make it a little bit worse, the polygraph examiner was a former Department of Defense polygraph examiner. And he wanted to introduce this as evidence of his innocence. Couldn't do that. He took the case to the Military Court of Appeals, which agreed with him, said, yes, that violated his constitutional rights, and the United States took the case to the Supreme Court. And I was arguing it. That almost every case has kind of a black hole. It's like a question that there really is no good answer to, and you sort of have to identify as an advocate what those black hole questions are and do your best to get out of it. If there are too many black holes, you're probably going to lose. But every case is going to have something like it. And the polygraph case, black hole, was that the Department of Defense had this thing called DODPI, the Department of Defense Polygraph Institute, and it employed like 500 polygraphers, and they were used constantly in security background checks and in criminal investigations, and many millions of dollars were thrown at this enterprise. So we kind of had a little bit of a disconnect between the military criminal justice system saying polygraphs are so unreliable you can't introduce them in court, and on the other side of the house spending millions and millions of dollars each year to polygraph thousands of people. So what do you do about that? And I spent a lot of time with my client trying to figure out what to do with that. In fact, I made an assistant to the Solicitor General take a polygraph test while I observed. We really needed to have somebody do it, and I didn't think it should be me. One of the reasons why is because in a polygraph test, the first thing they do is try to get you to tell a lie, because then they want to see what your physiological responses were. So they ask you super embarrassing questions about illegal or questionable stuff that you might have done in your life with the thought that you're going to lie about it, and then they see how your physical responses are. I didn't want to be asked about all the illegal activities that I may or may not have engaged in, but with advice of counsel, we're like, that's not leaving this room, right? So we did that. He ran through the test. It was a non-existent crime. The polygrapher watched him answer the questions. He denied having committed the crime. And afterwards, he ran out of the room with this long ticker tape of results and said, I knew it. I knew it. He showed deception. And I said, wait a minute. You're telling me my assistant showed deception in denying having committed a non-existent crime. He went, oh. So kind of had a little question about how I was going to defend this. And it ended up, I decided I was going to tell a story. And the story was there was a criminal investigation in Pennsylvania where a guy was being questioned for bank robbery. And he was denying that he had anything to do with it, never been to the bank, didn't know anything about it. And they put a colander on his head, attached 2 wires to it, and connected it to a Xerox machine. And every time he gave an answer that they didn't like, they pressed the button, and out came a piece of paper that said, you're lying. And the court laughed, and the suspect ultimately confessed. And the point of the story was whether or not the polygraph actually can identify lies and correlate physiological responses with untruthful answers. It's an incredible interrogation tool. So after that argument, Pete Williams called up our office and said, is that story true? And it's like, oh, yeah, we had definitely tracked it down, and we had talked to the department that said that they had done this thing. So he reported it as like, okay, that's true. I later found out that probably half the police departments in the country have a similar story. So it's one of those urban legends that kind of got around. But by that point, the case was over, court decided it, I didn't go back.
I love the relying on the urban legend for the win. So I think we have time for me to ask you one more question, and then I'll turn it over to the students. Okay. So to get us there, you talked a little bit before about your path. Do you have advice for our students if they're interested in careers in public service or government service?
Yes, I think you should definitely pursue it and keep it in mind, even if it is not the first thing that you do when you get out of law school. Your first job choice is going to be one that you may agonize about it. You may not. You may sort of think you have a dream job. You get it. You go there. That's fantastic. But I think it's really helpful to approach it with a little bit of an open mind in the sense that your career can be kind of a stacked layer cake of different experiences that are appropriate to different points in your life. And if you get a first job that you thought was your dream job and you discover it's not really in line with what you enjoy doing, you can change. It's not the end of the world if you discover that you need to change. There are a lot of lawyers out there who are not good managers. And what that means is that you can work for someone whose human relations skills are less than desirable. And that can make you incredibly miserable. And my advice is if that happens to you, find a way to leave. because there's no reason to spend a lot of time struggling to try to accommodate someone's personality who may not be accommodatable, period. There are a lot of opportunities. You're going to have fantastic opportunities. Take advantage of what law school has to offer, the clinics, the practical experience, the intellectual side of it, being able to go places for summer. Take all of those experiences and try to figure out what resonates with you and try it and see where it leads. It may lead you exactly where you want to stay. I've run into people who their entire career, they were in the same place. And I've run into people who have had like an amazing series of jobs. I sort of fell on the axis of not all that many jobs. Once I got into the government, I did not think that I was going to stay for very long. I thought it's going to be very cool. I'll argue a couple cases in the Supreme Court, then I will go back out and I will have something in private practice that distinguishes me from everybody else. And 30 years later, I was still there.
So what questions do the rest of you have? Michael for Michael.
You mentioned that you've made a number of mistakes over the course of your career. Could you tell us about how you recovered from them?
There's assuming a fact, not an evidence there. Some of them still a little scarred from. I actually thought about this a lot and did some research on it because I had a case that meant a lot to me. It was one of these confession of error cases where I thought that the law required us to take a certain position, and it was very controversial in the Department of Justice. Went through a lot of process. It went all the way up to the Attorney General before it was determined that I could present the argument that I wanted to present to the court. And I did that, and the court rejected it. And we actually won the case on a different ground than I had wanted to win the case on. So people called me up and congratulated me, but I felt like I just took the department over a cliff for no reason and lost this important matter. And for a while I thought well, I should do what anybody does in a government, when you completely mess it up, I should resign. And people told me, no, you really shouldn't do that. And for the sake of my children's college educations, fortunately, I did not take that advice. But I did then go out and research how do successful people recover from reversals, because you have them. They all have them. Have you guys seen the commercial that Michael Jordan has done, I think, for Nike? Something like, I took 3,000 shots in my life that I missed. 32 times my teammates entrusted me with the last shot of the game, and we lost. Those experiences are what made me great. So you're going to make mistakes. You have to accept it. I had to accept it as Deputy Solicitor General. I was probably making, ballpark, 1,000 decisions a year, just on whether we appeal this case or what we should say in this brief. And if you make a lot of decisions, you are not going to get them all right. So on some level, I had sort of accepted that. And it's okay, life goes on. This one really hurt. And so I started researching, what do these successful people do? And the first thing that they did was you give yourself a little bit of time to feel bad for yourself. You can't just deny that you are hurting. And so I was kind of grieving for a little while. And then you sort of get busy. You say, okay, fine. I may not be quite ready to emerge from this kind of self-pity, but you got to get down and do the job. And then the third piece of it is when you have enough time to do that, kind of reflect on what happened. And it may be that you conclude, yeah, I lost this case, but they were wrong. I did the right thing. Or it may be that you conclude there was something that I missed, some trigger that I didn't focus on, that I should have focused on. And in that particular case, that's what happened. I came to think that I really wanted the case to come out a certain way, and there was a problem in it. And I had a lot of strong arguments, but I had this one black hole, and I kind of pushed it to the side, and I didn't really solve it. And it made me aware that when you have a doubt in your mind, your intuition is telling you something, some people will call it your gut, it's important to listen to that and not just assume, I'm going to get around this by some technique that overlooks what your gut is telling you. Yes?
So I think traditionally and continues, the line has kind of been that you need to go into private practice first and go to a firm to get that type of training, especially for a lot of kind of appellate government positions. Have you seen a shift or a trend in that change in kind of what's expected to go into roles like yours?
I haven't seen that kind of a change. If anything, I've seen many more people coming out of private practice at more senior levels who want the experience of being in the government. And the reason why they want that is control over their lives and the opportunity to represent a client that you may not always agree with, but it's the public interest. And for some people, those are driving factors, particularly people who want to balance parenthood with a job. Appellate law is really good for that because you can work at home, you can control your schedule, you don't have to have your blood pressure spike by having really obnoxious adversaries call you on Friday to say they're delivering a motion that's due on Monday. So it is still probably the more traditional route to the Department of Justice, at least, to get that kind of experience. That said, it doesn't have to be all that long, and the Department of Justice is not the only entry point to government work. There's lots of other government agencies, many of which do hiring off of clerkships or out of law school. The Justice Department does that too through the honors program. There are many excellent legal offices in the states and in counties where you can get fantastic experience and work with really dedicated people who have probably also made career choices that value a balance in their lives. Private practice, particularly starting out, is at a big firm, high level, big law. It's a lot of work. It may be rewarding and it may be good training, but it is a lifestyle choice that not everybody is going to make. Yes?
Along the same lines, have you seen an increase in diversity in terms of the institutions people are coming from, the backgrounds that they have, and does that change the kind of conversations you have when you're trying to figure out how to address any individual matter?
You mean within the Department of Justice as far as hiring goes, or in the legal profession as a general matter?
I guess either specific. Yeah, the Department of Justice for the most part. Just I think we tend to think of people in Solicitor General's offices coming from the top 14 law schools and predominantly being white men. Maybe way back when, but no, now we're in maybe a different era. And is that true? Are we in a different era?
Well, I think we certainly should be in a different era, both on two levels. One is any workforce is healthier if it's diverse. And if it's not, you're simply excluding incredibly talented people who don't all look like each other. I just think being in an environment where there is diversity is going to produce better results. So yes, the Department of Justice has made a concerted effort to ensure that it is diverse, and diversity is also manifested in background, what law schools you come from. The SG's office being tiny and very focused on one thing is using a couple of proxies to figure out who is going to get those jobs. And one of them is law school performance and law school. And the other one is recommendations from trusted people. So those kinds of pathways may or may not correlate with diversity. You really have to kind of work hard at it. But I would say that any institution of government now that is not paying attention to those things is going to lose out, and the pressure is all in favor of being more diverse. And Duke, you're lucky. You're going to an excellent law school, and it's going to give you a lot of opportunities that are harder to get at other law schools.
next.
I have a question about two different roles lawyers can take, either advancing your kind of like personal ideology or advancing this like whatever justice, like the more nebulous concept of justice for me at least. Did you ever have a case where you thought the government had been pleading an error, but you had engaged in an affirmative case that you like personally really didn't agree with, and how did you navigate that?
I had plenty of cases that I thought we would and should lose. I mean, as a lawyer, you can figure out, some of the cases, like this one is just not going well, and those black hole questions, if you have a whole lot of them and everyone is giving you the same funny look when you say your answer, you can get a pretty good idea you're going to lose. That never led me to think, I can't represent the United States in that instance. There's a process, and it's an adversary one, and I made the arguments on behalf of the government, and somebody else was being heard, and the court decides. The ones where I wanted to confess error were ones where I thought some injustice was being done that was not the right thing for a government to do. Ordinary legal disputes that could go either way, it's like made the arguments. I never actually did have a case where I felt so deeply at odds with the position that I could not do it. I had a couple where I came close, and I really had to search my soul about whether I could do it. And there are two tripwire points. One is, if you really are at odds with the position, you might not be the most effective, zealous counsel to represent your client. And if that's true, you should step aside just because you're not going to be able to perform up to the standards that you probably hold yourself to, and certainly that the client is entitled to respect. And the other one is sort of the, are you going to be able to look yourself in the mirror test? And if you hit that tripwire, then you should be out for that reason as well. But as I said, everybody has a pretty different spectrum of where they fall on that. It's not really a one or the other dimension, and it's one that you may learn things about yourself as you go forward. I'll say one other thing about that, and the dean and I were just talking about this as we were walking in here. Sometimes you may think, I can't do this representation because I don't agree with this particular client. Like they are, I'll just pick one. I know nobody actually feels this way, but if you thought like polluters were evil, you might think, I can't represent this evil polluter. You might actually get into the case and realize, well, actually, this was a horrible episode of pollution, but my particular client came into it at the end. They exerted incredible environmental controls. Not only did they not contribute to it, they did everything they could to mitigate damage by other people. And they've been sued because nobody knew, but I now have the facts, and I can see that they're not justly being held responsible for it. And I think part of the answer to the paradox and the kind of moral quandary that you may have about some cases is find out as much as you can about them before you make a judgment. We're all going to have snap judgments, but one of the key attributes of a lawyer is to first figure out the facts, because they may not be what you thought they would be, and you may have a different view of the case once you fully understand it. And that ability to sort of withhold judgment, gather the facts, neutrally do it, is a legal skill that should really come before the judgment part of the exercise.
Thank you so much, Michael. You're an inspiration, and we are so proud to call you an alumnus of Duke Law.
Thank you. Proud to be here.